honorable court are admonished to draw near and give attention, for the court is now sitting. The case of Vandalia Alliance for Clean Energy versus Franklin Power Authority will now be heard. God save the United States and this honorable court.
May I proceed, Your Honors? Good afternoon, Your Honors, and may it please this court. My name is Eden Foray, and I, along with my co-counsel, Mr. Christopher Cerny, represent the appellant Vandalia Alliance for Clean Energy, or VACE, in this matter. At this time, I would like to reserve 2 minutes for rebuttal.
All right.
Thank you, Your Honor. I will be arguing the first and second issues of 4 in this consolidated appeal today as pertain to the Migratory Bird Treaty Act, or MBTA. My co-counsel will argue the Clean Air Act issues before the court. Unless Your Honors would like a brief recitation of the facts, I will proceed with my argument.
I think we're all familiar with the facts.
Thank you, Your Honor. The issues before this court today concern the remaining true to the statutory language of the MBTA in light of the tragic and illegal taking of migratory birds by the Franklin Power Authority and the FPA's subsequent attempts to skirt compliance and accountability under the act itself. In the last 3 years, FPA has taken over 2,000 migratory birds via its concentrating solar power plant and has refused to take mitigation measures to bring itself in compliance with the law. Your Honors, FPA must be held accountable for its violations of the MBTA in pursuit of energy generation. To ensure full compliance with and enforcement of the MBTA, VACE respectfully requests this court reverse the findings of the district court that FPA is not liable under the MBTA and subsequently enjoin the FPA from further takings in violation of the act. Your Honors, the MBTA's plain language unambiguously indicates that it applies to all parties, including federal agencies like FPA. To read,
well, why isn't Solaris the one responsible? Maybe it'd be different if FPA was the one operating East Gem, but that's not the case before us today, is it?
Your Honor, Solaris cannot be seen as an intervening party here. FPA retains managerial discretion over all decision-making power made at the plant. Solaris merely serves to operate and maintain the plant. FPA retains decision-making power, as I said. It indicated on page 6 of the record is that FPA is even involved in the annual budget review process over Solaris and has declined to take mitigation measures and instructed Solaris to operate in that way. FPA is certainly acting, is certainly the actor who should be liable here.
Isn't it more their role, more regulatory like that we saw in the Jewel case though?
Your Honor, I would argue that it's not FPA's, VACE's position is that FPA is acting in a managerial role here. Again, it's selected Solaris to operate and maintain the plant, but otherwise, FPA retains decision-making authority over it. Again, it chose not to employ potential mitigation measures and is acting directly here, Your Honors. The plain language of the MBTA is clear.
Well, counsel, isn't it also the case that there's some dispute as to what constitutes a violation of the MBTA in taking, and that may involve either an intention, it needs to be an intentional act as to an inadvertent act. And isn't the argument that what's happened here is really inadvertent and there's no intention at all on the part of either the FPA or, if you get to Solaris?
Your Honor, VACE contends that there has been a taking here, and you highlight a kind of a bifurcation here, which is the intentional versus the incidental takings. It's VACE's position that FPA's destruction of over 2,000 migratory birds does constitute a taking under the MBTA. A really important principle here is proximate cause. Courts, including the 10th Circuit and US v. Apollo, have held that actors are required to proximately cause the taking to be in violation of the statute. And FPA has done, excuse me.
What is the rule, though? The new Biden rule doesn't actually give us any standard to go off of, does it?
Your Honor, the Biden administration's reversion that just occurred is a reversion to long-standing agency interpretation that this is a strict liability statute and that incidental takes are contemplated within the language of the statute. Your Honors, it was reasonably foreseeable that the East Gen site was going to cause widespread avian mortality. Per page 6 of the record, this facility was sited by FPA right in the middle of the Mid-Atlantic Flyway, which is a popular migratory bird route, including protected species. This information was well known to FPA at the time of siting. Further, over 2 years before operations began at East Gen, FPA knew that it was going to need deterrent technology if it wanted to stop avian mortality, and it chose not to pursue those mitigation measures based on cost alone. Additionally,
I want to
FPA
be careful about the precedent that we set, though, when we talk about incidental taking and the Biden rule not having really given us a standard to go by. It would seem that that can lead to unreasonable interpretation of taking, and that any building where there are birds, where there are problems with birds, will be able to be liable if we give it that broad of an interpretation. And we want to be careful about how we define incidental taking, and we really have no guidance under the rule here.
Your Honor, FACE absolutely understands the desire to have a clear rule, and proximate cause does act as a discretionary kind of limit on this strict liability. There does have to be that reasonable foreseeability, but further, I would offer to this court that both the 2nd and 10th circuits have found in this way as well. They've found that liability is triggered for all actions that lead to the deaths of protected birds, regardless of intent. And that case law is persuasive here. In the 2nd Circuit in US v. FMC Corp., the court held that the MBTA does impose strict liability for misdemeanor violations, and it affirmed that an entity's conviction for avian mortality at its energy site. Further, the 10th Circuit in US v. Apollo has offered that the take requirement under MBTA is a strict liability misdemeanor crime as well, and it covers all deaths of migratory birds. There is
so
no
counsel, to what extent though should we take into consideration what Solaris or FPA knew about the construction of their plant, where it was, the nature of it, what harm it would cause to birds? To what extent should we take into consideration those facts? And are they favorable or unfavorable to you?
Your Honor, those facts are significant here, and they are favorable to us because it's clear from the record, as I stated just slightly before, FPA knew what these mitigation measures it would need to take. Actually, FPA conducted studies to assess both the extent and nature of its East Gen facility on avian mortality. It found, as a result of that study, which is footnoted on page 7 of the record, that avian mortality was most certainly connected to concentrating solar power technology. It knew this would happen. It went so far as to have these mitigation measures laid out and then still refuse to take those mitigation measures. So it is significant here, Your Honor, that FPA knew about that. Because
I want to go back though to Sitka. If Sitka is binding on us, I don't understand how you can possibly prevail. And it seems to me that it is. Judge Alley's earlier question about intentional acts, or perhaps was Judge Berger, touched on that as well. And I'm not really satisfied with the answer.
Your Honor, there is binding precedent in this circuit, as you've stated. However, the regulatory landscape is changing here. And while the most recent Biden rule has not yet been codified, we should afford deference to the agency's decision to revoke that Trump era rule. Again, the Biden administration here is reverting to a long-standing interpretation that it's held. The Fish and Wildlife Service has time and time again interpreted this act as a ban on taking migratory birds, regardless of intent, and that brief political digression during the Trump era should not be read as anything other than that. And it's telling that the agency has returned to this interpretation. The agency itself, Your Honor, has noted that that Trump era rule was neither indicative of the best interpretation of the statute's language or purpose, and further that it doesn't follow long-standing case law. And so we would urge this court to follow that agency's interpretation rather than that Sitco.
The Biden regulation, though, in reversing the Trump regulation, they have not in any way told us why that position is preferable. Would you agree with that?
Your Honor, I unfortunately don't have anything in the record that quite indicates that intent, but we do know that the Biden administration intends to codify that, and it should be afforded deference, Skidmore deference, if it's, we give agencies these determinations because they do have that expertise and they have that knowledge that we don't, and it's important that we defer to them as long as that is a reasonable determination, Your Honor.
Okay, let's take you at your word there. What about Title V, using it to re-examine Title I permits? It's an EPA's decision to not object, to serve that very same deference you're speaking of. As an EPA the expert?
Your Honor, my co-counsel will cover the Title I and Title V issues. I'm happy to try to answer your question if you'd like me to, but I can also reserve that for him as well.
That's just fine if you have split your time in that fashion.
Thank you, Your Honor. I want to return with the remaining time I have left. I want to ensure that I've left Your Honors with significant case law that shows that the MBTA does bring agencies, federal agencies, under the language of the MBTA itself. The Fish and Wildlife Service has, or excuse me, let me take a step back. The MBTA includes explicit exceptions within its language for people who are, or entities who are able to take protected birds. The Fish and Wildlife Service issues permits that authorizes takings in limited instances, and further, Congress has carved a specific exception for incidental takings by the military. It has provided an exception for military readiness activities after liability was imposed in a Center for Biological Diversity case. So, Your Honors, Congress has provided that there are exceptions to the MBTA, but they do not apply to federal agencies. And if Congress had intended to create a caveat for federal agencies in this way, it would have made that clear. The Supreme Court in Andrews v. Allard found that there was no exception to be implied to limit the scope of 703, because when Congress wanted an exemption for that statutory prohibition, it did so in unmistakable terms. The MBTA is a comprehensive statutory prohibition from which no statutory exception can be implied, and because they did not carve out that exemption here, this court should not read a wholesale exception for federal agencies into the language of the statute. Your Honors, the purpose of the statute is also to restore and protect migratory birds, and it would be really difficult to achieve that protective purpose if we stopped everyone but federal agencies from illegally taking birds. It's important, or we would urge this court to follow the purpose of the MBTA and its underlying treaty here. Your Honors, the court should enjoin FPA's operations even if its takes were incidental. And in conclusion, the FPA must be enjoined from its role in killing over 2,000 migratory birds in the last 3 years. Respectfully, VACE would ask this court to reverse the district court's findings that the MBTA does apply to federal agencies and that the FPA took birds in violation of the act. Thank you, Your Honors.
Thank you, counsel.
Thank you.
Good afternoon, Your Honors, and may it please this court, my name is Christopher Cerny for the Vandalia Alliance for Clean Energy, or VACE. As my co-counsel, Ms. Foray, said, I will be addressing those Clean Air Act issues today, and they're arising from two consolidated actions. These issues are about embracing the cooperative federalism that is built into the Clean Air Act and ensuring the proper mechanisms of enforcement are in place to hold federal facilities accountable for violations of state air pollution laws. In the first action, the EPA's failure to object to the issuance of a Title V permit for Franklin Power Authority's Eastgen facility is arbitrary and capricious. It is contrary to the plain language of the EPA's own regulations, and it's against the manifest weight of agency precedent. In the second issue, the lower court erred by failing to remand and by holding that the FPA may claim sovereign immunity. The Clean Air Act bars removal, and it waives sovereign immunity for federal agency violations of state air pollution laws. The appellant respectfully requests this court reverse those decisions. Judge Volk, I just want to immediately address your issue of whether does the EPA, are they do any deference in this matter? And in the underlying action that is on appeal here, no, they do not. And this is because the regulatory language implementing Title V is clear. But just to take a small step back and frame the issue a little bit and how Title I and Title V work together, Title I permitting is the stage at which a permitting agency evaluates potential emissions, and it determines whether the source is a major emitter or a minor emitter. It is conducted in accordance with EPA-approved state implementation plans, but it's a snapshot decision. It doesn't necessarily take into account changing operations, changing demand loads. Title V, on the other hand, ensures that an emitter's compliance with all of its underlying permits happens on a regular basis every 5 years. This process affords the state agencies and the EPA the opportunity to evaluate those underlying permits. The statute that implements Title V, it requires that Title V permits include all the conditions necessary to comply with the applicable requirements of the Clean Air Act. Applicable requirements is broad. EPA recognized that likely is ambiguous. And so they implemented regulations, they promulgated regulations defining
I think I understand
applicable
the
requirements.
direction you're going, counsel. I suppose I'd ask you about sovereign immunity. Isn't the issue of sovereign immunity unequivocally better suited for litigation in federal court?
Jumping to sovereign immunity, I would push back, Your Honor, that it is unequivocally better litigated in state court. And this goes back to what I was mentioning earlier is the cooperative federalist structure of the Clean Air Act. The Clean Air Act vests states with the ability to make their own implementation plans, as I was discussing, or enforce their own state air pollution laws. And so to provide them with all of these rights and obligations, and then to say at the very end, oh, we don't trust you in a state to evaluate whether sovereign immunity can be applied in this situation. This then divests them of all this authority and obligation that has been provided through the rest of the Clean Air Act. I do want to jump back to the title.
Yeah, I want to go back to this whole standard of review. So identify for me the set of facts that that you rely upon that makes this decision by the EPA arbitrary and capricious, because that's a hard standard. So I want to understand what your set of facts are that will convince us that what they've decided is so wrong, so arbitrary, so capricious that we should set it aside. And you can understand why courts are loath to do so. We have enough to do.
Your Honor, thank you for bringing me back to the Title I and Title V issue. EPA, as I was mentioning, codified its interpretation of applicable requirements at 40 CFR 70.2. It said that any standard or any other requirement provided for in the state's implementation plan shall be part of a Title V review. So the EPA's underlying decision, Your Honor, to answer your question, in this case is arbitrary and capricious because it flatly holds the opposite. They have determined that Title V does not include that Title I review, which is directly at odds with its own interpretation that has been promulgated and codified. And certainly a one-off adjudication that is in odds with a long-standing codified regulation is the picture of arbitrary and capricious. This has been recognized almost word for word by the 10th Circuit in Sierra Club v. EPA. Other courts, however, have also found, the EPA's duty to object in this situation would be triggered. Your Honor, for these reasons, because the EPA's own regulation and because its longstanding precedent are clearly at odds with its decision in this action, the court should find that the EPA did in fact act arbitrary and capriciously and remand.
Counsel, it
Moving
seems to
back to the
me,
removal, oh, pardon me.
it seems to me if we accept your interpretation, that it pushes into the process a lack of stability in the permitting process. Here, if you went through the Title I, there was an expansion, and if every 5 years we're going to look back at whether or not that was appropriate, it seems to force instability into the entirety of the permitting process, if we accept your interpretation.
No, Your Honor, it does not reevaluate the underlying Title I permit according to any changing standards or variations that may occur regarding that Title I definition or how Title I is perceived. It just ensures that the Title I permit complied with the mandates in place at the time, and that over time, it proves that that in fact was, at the time of issuance, a minor source. And in this case, it was not. It was a major source at time of issuance, and it was only delayed until VASE was able to determine that factually. I do want to move Your Honors to removal. 28 USC 1442 normally permits federal agencies to remove any action originated in state court, regardless if it could have originated in federal court. But this is not absolute. If there are bars elsewhere that prevent a district court from asserting jurisdiction, this general removal provision, it can't overcome those jurisdictional deficits. 42 USC 7604, that's one such statutory bar. It states that nothing in any other law shall be construed to prohibit, exclude, or restrict a state from obtaining judicial remedy in state or local court. Obviously, broad language, nothing in any other law. But further, the inclusion of judicial remedy is obviously very important. It doesn't say to bring an action in state court. It says to achieve judicial remedy, a solution in state court. Beyond just the language, the general rules of how we interpret two statutes when they conflict like this guide us that a statute that's a later passed statute will not repeal an earlier statute unless that construction is the only way to give that later statute any meaning at all. Further, a statute that deals with a narrow and a precise and a specific subject is not submerged by a later enacted statute that covers a more generalized spectrum. Section 7604E is that narrowly tailored statute. It addresses a specific subject. The broader federal removal provision cannot repeal the Clean Air Act's grant of specific jurisdiction. This court should reverse the lower court's holding that it has jurisdiction at all over this action and remand to the state court of Vandalia. And finally, Your Honors, moving to sovereign immunity once again.
So are you suggesting in your argument, counsel, that the federal court, it is error for the federal court to hear this matter, and it's error for it to have permitted it to be removed?
I want to clarify, Your Honor. It was an error that it was removed. It is not an error for a federal court to hear this matter. The federal removal provision.
Well, stop. I mean, if if it's not air for us to hear it and someone removes it to federal court, I mean, were we supposed to say, no, we're not going to hear it, take it back?
Yes, Your Honor. In this instance, removal itself is barred. And so jurisdiction
Okay,
over the
so logically, if they had filed with federal court in the first case, it'd be okay. It was just a removal that is the problem for you.
Yes, Your Honor.
And that seems to cut against your interpretation of the statute that you argued earlier about obtaining a remedy in state court, whether it be by removal or whether it was brought in federal court in the first instance. As I understood your response to Judge Alloy, it would have been fine had it been brought here initially, but it is the removal that's improper. That seems to be contrary to the earlier argument you made regarding the interpretation of the statute that it wants or requires a remedy obtained in state court.
Your Honor, I appreciate the confusion and I apologize. The statute, as I discussed it earlier, it does not mandate that it is heard in state court. It mandates that once brought in state court, it must be heard there. So it is not it does not direct these to only be heard in the state courts, but if a state chooses that lane to pursue remedy, that is where the action must lay. I do want to move to the last issue.
Let's talk about some. Yeah, I was going to say, let's talk about sovereign immunity and why that doesn't just take you out of this case altogether. You shouldn't be taking any action against the FPA because it's a governmental agency and sovereign immunity.
The Clean Air Act, Your Honor, waives sovereign immunity in two separate sections. In section 7604E, which we've been discussing, it says that nothing in any other law will stop a state from obtaining a judicial remedy or obtaining an administrative remedy. So again, the broad language of nothing in any other law, that must include sovereign immunity as another law. It's important that it includes both judicial remedy and sanction and administrative remedy and sanction. The inclusion of both means that it cannot be merely coercive penalties that it conceives of. Administrative agencies rarely can impose coercive forward-looking penalties. So limiting the issue to citations, to failure to comply with past actions would extract, would prevent enforcement by administrative agencies. And again, I did say that there are two reasons it waived. The second is the federal facilities provision at 7418 of the Clean Air Act. And it states that federal agencies shall be subject to the process and sanctions, notwithstanding any immunity of such agencies. A clearer waiver of sovereign immunity, Your Honors, is likely hard to find. For these reasons, this court should reverse the lower court's dismissal because the federal facilities provision and the state suit provision clearly waives sovereign immunity. Thank you, Your Honors.
Thank you.
Your Honors, may I proceed?
Yes, you may.
My name is Autumn Brihan, and along with my co-counsel, Brianke Ezeguirre, we represent the appellee in this case, Franklin Power Authority, or the FPA. I addressed the first two issues, specifically whether the Migratory Bird Treaty Act, or Mbta, applies to the FPA, and whether the FPA took birds in violation of the Migratory Bird Treaty Act. My partner addresses the second two issues regarding Title V permits and the issue of removal as it relates to sovereign immunity. The case before this court today is really about a special interest group trying to force a statute, the Mbta, to do something it was never designed to regulate: accidental bird deaths by energy companies. The district court correctly granted the motion to dismiss because the MBTA.
Counsel, we have to stop right there. I mean, if we are to take your argument literally, there is no protection for birds under the act in this situation. I mean, is that what you're arguing?
Your Honor, there is protection for birds in situations. However, unless appellants can prove that the FPA is acting more in a managerial role than in a regulatory role, the statute does not contemplate secondary attenuated liability.
Sure, but this whole relationship with Solaris is just a ruse, isn't it? I mean, I can't accept that we just say, oh, it's Solaris and not FPA and let the birds die. I mean, that shouldn't be right, is it?
Your Honor, page 3 of the record indicates that the FPA was created by congressional statute. And with that statute, it was created to take care of an area of energy instability that was happening on an international scale. And so it's not a ruse that the FPA would look to a third party who was better able to manage the energy needs of the military-based facility by which it was operating to make sure that it's properly accomplishing the aims of its statutory mandate.
And that may be true if we look at it generally in response to Judge Alloy's question. But here there was an operations and management agreement where your client maintained a lot of control and control that, depending on the interpretation, it could have taken some mitigation measures with respect to the birds. It isn't a situation where there is just management and no involvement by your client, is it?
Your Honor, the only involvement on part of the FPA as it relates to Solaris's operation of the EastGen facility is that management and operation agreement, which then has that reimbursement that happens on page 7 of the record. And so appellants are factually incorrect in stating that the relationship is much more stronger and managerial. The congressional mandate that sets up the Franklin Power Authority simply requires that it reimburse any third parties for operation costs. And so that's the only secondary link that's found on the record. That is not strong enough to change the FPA from a regulatory agency into a managerial role. It's also true on page 7 of the record, Your Honor, to make sure I'm answering your question thoroughly, that Solaris also looked at mitigation measures and sought not to enforce any of those mitigation measures. And so it's not a factually true statement to say that FPA was 100% in control of any behavior that Solaris also might have taken.
Well, you know, counsel, that's what I find interesting, that it appears to me, and maybe you're not making this argument, that because Solaris is the one who really had all this information, that what they were doing in the location, and they knew that these solar panels and all were going to fry the birds as they flew over. But yet you're arguing, it seems to me, and if not, clarify, that that's why FPA should not be responsible for this and the act should not apply, because Solaris knew and did studies in advance that this was going to kill birds. Now, if I misunderstood that, please tell me, because I hope that's not the case.
Your Honor, thank you for the opportunity to clarify 2 points to that question. We're simply clarifying for the record that the FPA is more regulatory than managerial, and that really cuts at the heart of the appellant's argument, because the only way to bring FPA in for liability is through that argument that it's more managerial than regulatory. However, Your Honor, to the second point of your question, that takes us directly to the heart of the Joule case, because it's important to understand that in the Joule case, a third party similar to Vandalia Alliance for Clean Energy, or VACE, sought to have an injunction, not just for the actions of what there was the Bureau of Land Management and the Department of Agriculture, but also for that third party that was granted the opportunity to have that windmill facility. And there, the Ninth Circuit found that not only were those federal agencies not liable, but also that third party was not liable. And so to make sure I'm answering Your Honor's question more directly, FPA is not asserting that Solaris would simply be liable and the FPA would not. Rather, good standing language from the Ninth Circuit in 2016 in Joule says neither Solaris nor the FPA would be liable. And this is because in Joule, the court focused on the fact that the operational nature of the facility doesn't strengthen that causal link that's missing. And for there, the causal link for them is that the taking by the wind turbines was too attenuated for the behavior on behalf of that third party operating the facility, or for what would now be the FPA or those agencies at that time.
You know, counsel, go ahead. I'm sorry, Judge Vogt. Go ahead.
Well, I appreciate that. Ms. Burhan, I'm just wanting to cut to the core of this. You know, when they say when in doubt, go to the text, why should federal agencies be treated differently than private entities when clearly the MBTA was intended to protect birds with the strongest possible language?
Your Honor, again, going straight to the heart of the language of how courts have interpreted this case, and we can look to Joule as well as Citgo Petroleum Corporation, it's not that federal agencies like the FPA are being treated differently than private corporations. Again, even in Joule, that third-party private operator was also found to the link between the taking of the birds that happened in Joule was also found to be too attenuated for even the third party there. And so there does not need to be a discussion of federal agencies receiving some sort of preferential treatment from executive departments, because good case law says that that's simply not the case. This gets us also to the heart of the appellant's rule, which focuses primarily on the new Biden policy that vacates that Trump order. And it's important for this court to note that relying on the Biden rule actually creates more problems for the court than it solves. And this is important because that language of Citgo and Petroleum Corporation are still good standing law that a court could rely on as opposed to the Biden rule. Several of the issues with the Biden rule, for example, are that it does not provide a standard by which courts can operate. This is important for the court because in resolving a circuit split or in resolving cases like the one at hand that are factually nuanced from Joule or Citgo Petroleum or even Apollo Energies and FMC Corporation, as our appellants note, there is no standard by which courts can operate. This is also important for a second reason. Something that was very important to our friends across the aisle were the mitigation measures that they say were not followed. However, under the Biden rule, there is no guarantee that even if the FPA or Solaris left today with an injunction and had any mitigation measures in place, if one bird were to die, Vandalia Alliance for Clean Energy could drag FPA and Solaris back into court. And so even under the—
I think what you're suggesting is that we sweep the Biden new rule under the rug. Why shouldn't we defer to that? Doesn't that deserve Chevron or perhaps at least Skidmore deference?
Your Honor, 2 points to that. First, Skidmore should not control here because the Biden vacation of that Trump era rule is not persuasive. And second, with the vacation of the Biden rule, we still have that good standing law from the 8th Circuit as well from Citgo Petroleum and as well as Joule. This really cuts to the heart of the appellant's issues when they raise the case site examples of Apollo.
Didn't Citgo in our decision on the 12th Circuit just analyze the word take? Doesn't the word kill also appear in the definition of take, and weren't birds clearly killed here?
Your Honor, when the language of the Migratory Bird Treaty Act was originally ratified, it did not define the language of the term take. That was defined later in Seattle Audubon Society versus Evans, which was a 1991 decision. So it also predates the Biden rule as well as the Trump rule. However, even under the language of the rule from Seattle Audubon for Society versus Evans, that language still fits with what FPA is arguing on behalf of the court today. And this is because the word take has a common law definition that's, quote, as old as the law itself, and that's from Babbitt versus Sweet Home. Additionally, absent any contrary indications from Congress, the courts generally presume that Congress intends to adopt the common law definition of any statutory terms.
Okay, so how are you wanting us to define take?
Your Honor, we're asking this court to rely on the definition from Seattle Audubon Society, which defines take as, quote, to pursue, hunt, shoot, wound, kill, trap, capture, or collect. And this isn't—
Well, how is this not, at least I understand the factual evidence is that Solaris knew exactly what was going to happen when these birds flew over and they built it within their route. and they chose to ignore that. And it's hard for me to find that something other than an intentional killing of these birds, knowing that it was going to happen. And anything else seems to me to split hairs.
Your Honor, this case is not about splitting hairs. It sounds like the court is also interested in the word kill as it relates to the word take. However, our friends across the aisle, Vandalia Alliance for Clean Energy, understood that they could not bring a case to court under the language of kill because it understands that neither the FPA nor Solaris would meet that mens rea requirement that's required for a killing. And that's why it's seeking to rely on that word take. However, prior to the Biden rule, as well as the Trump administration rule, that term take has a common law definition that does not contemplate secondary attenuated liability. It does focus exclusively on affirmative acts.
You're not suggesting that taking is that killing's okay, but taking is not under the language?
No, Your Honor, I'm not.
Okay.
No, Your Honor, thank you for the opportunity to clarify. I'm not suggesting that killing is okay, but that taking is not. We are simply drawing out the flaw in our appellant's argument, which is that the reason they did not bring a claim against FPA or Solaris under the language of kill is because Vandalia likely understands that FPA nor Solaris meet that mens rea requirement that's required for a killing. And so they're seeking—
Why is it good public policy that we ignore what this facility is doing, which is the death of 2,000 birds, which are environmentally important to our ecology? I mean, I think y'all are just saying too bad. Law permits it.
No, Your Honor, we are not saying too bad. And I would like to clarify on the record, there was a study that was done by an environmental agency that predicted potentially 2,000 birds had died. However, the record affirmatively finds only several dozen birds that were accidentally killed at the facility. And so I would like to clarify for the court, there is no guarantee that upwards of 2,000 birds have died. However, it is good policy for this court, especially with an issue like this that involves a circuit split, as it relates to energy companies during an era of energy instability, to rely on good standing case law so that energy companies, as well as other federal agencies that are created through statute, understand how to conduct and operate and turn their behavior accordingly. And that can't happen under that Biden rule, which reinterprets Section 703 of the MBTA. And so it is good policy to rely on standing case law that's before this court so that energy companies and federal agencies know how to conduct and comport themselves. This is important.
And consistent with Judge Alloy's question, it seems to me that if we accept your interpretation regarding incidental killing, that is going to be inconsistent with the policy and purpose of the MBTA. It seems to say, as long as birds are incidentally killed, there's nothing that can be done about it. That seems to cut against the policy of the MBTA in an effort to try to save birds and to put some responsibilities on entities like your client to take measures to try not to kill birds.
Your Honor, I see that my time is almost up. May I answer your question and briefly conclude?
Yes, please, and thank you.
Thank you, Your Honor. Just a brief overview. The history of the MBTA was never designed to regulate behavior by energy companies. Prior to the treaty agreement between what was originally the United States and Great Britain on behalf of Canada, the MBTA sought to implement, which at the time were two federal statutes, the Lacey Acts and the Week-McLean Acts. And those acts were important because they were trying to regulate very specifically and explicitly the behavior of hunters and poachers. It was not until successful Commerce Clause arguments by states' rights activists that the courts sought to go through a treaty route to protect birds from hunters and poachers. And so to answer your question directly, it is still within the spirit of the Migratory Bird Treaty Act to hold that federal agencies are exempt when they are acting in more of a regulatory than managerial role. Thank you.
Thank you.
Your Honors, may I proceed?
Yes, please.
Your Honors, and may it please the court. My name is Brianca Isidre, and together with my co-counsel, Autumn Brihan, we represent the appellee in this case, Franklin Power Authority, which I'll refer to as FPA. FPA respectfully requests that first, this court uphold the EPA's decision to deny VASE's appeal because Title V of the Clean Air Act is the inappropriate vehicle for evaluating an underlying Title I claim. And second, this court should affirm both the district court's denial of the motion to remand the Clean Air Act civil penalties action to state court and the district court's dismissal of all civil penalties against the FPA. To my first point, the EPA was correct in determining that Title V is not the appropriate vehicle for evaluating an underlying Title I permit. Opposing counsel does note that we need to look at the mechanisms of enforcement that VASE might have, but in order to do so.
But frankly, though, with respect, EPA has waffled back and forth on this issue. Doesn't this waffling suggest it's better for the courts to definitively decide the issue since it's frankly one of statutory interpretation? That's what courts do all the time.
No, Your Honor. And let me point first to case law and then second to alternative methods to address this issue in order to answer your question thoroughly. It's understandable that Your Honors may be, or I guess use the word waffling. There's some waffling between courts, and that's because the two leading courts we have, or decisions, regarding this issue are in a sense split. Opposing counsel referencing Sierra Club versus EPA out of the 10th Circuit, and that's a holding done out of the 10th Circuit only in regards to regulatory language. Quite recently in environmental integrity protection versus the EPA, the 5th Circuit has ruled on the statutory language. But it's critical to note before diving into the text of these statutes that there were alternative routes that Vandalia Alliance for Clean Energy could have used to seek remedy in today's case. The first would be to look at the state implementation program. The Clean Air Act operates on a cooperative federalism model, and state implementation programs must meet the requirements of the Clean Air Act, but aren't prohibited from going above that. To seek redress could be more properly done within a state implementation program and their evaluation of major and minor sources. A second avenue for which VASE could have sought redress would be through an enforcement action directly with the EPA. And finally, and most critically, the Clean Air Act still contains a citizen suit provision within Title III, that's Section 1365 of the Act, for which redress could have also been sought. It's not the FPA's position that we take away any remedy from VASE, but rather that Title V is simply the inappropriate vehicle, and we can first turn to the statutory language for this. As Your Honor,
counsel, I asked the counsel for VASE this, and I'll ask you. What is the standard of review in regard to our review of this issue, and what are the set of facts, the specific facts that you rely on to say that the court was correct in its decision?
Your Honor, the standard today, as opposing counsel did note, is arbitrary and capricious, but it's not the FPA's position that that standard is met. And that dives directly into the Holding an Environmental Integrity Project versus the EPA, for which analyze both the language as well as the congressional intent behind Section 7661CA. We begin with the applicable requirements language. As mentioned in the Act, is the applicable requirements of this chapter, including requirements of an applicable implementation plan. A clearer reading of this is in line with the questioning done by Your Honors with opposing counsel. And it's that, as the Supreme Court notes in Whitman versus American Trucking, Congress does not intend to hide elephants in mouse holes. A complete reevaluation of a Title I pre-construction permit in such a short amount of time through Title V is an elephant in that mouse hole. And considering that there are numerous other avenues to seek that same type of enforcement, it simply just was not what Title V was intended to do. And in the Fifth Circuit's holding, it directly relied upon the congressional intent to develop a streamlined procedure within Title V. If you look to the legislative history, it mentions the idea that Title V, created after the original inception of the Clean Air Act, was to be done so that it streamlined procedures for expeditious review. A complete reopening and analysis of a Title I pre-construction permit goes contrary to this congressional intent. It goes against the streamlined nature of the Act, and requiring a reevaluation of Title I permits effectively introduces new substantive requirements. And such a requirement would run counter to the statute's goal, once again, of streamlining. But it's important to also note the permit history regarding East Gen as cited on pages 5 and 6 of the record. Originally, in 2008, a Title I pre-construction permit was granted for East Gen, and then in 2010, discussions of adding a concentrating solar array began. That means from 2010 to the point at which we're looking in today's case, that is the 2018 Title V permit, it's an 8-year gap for which VASE could have sought any type of remedy against FPA. And in that gap, as I mentioned, in those other alternative remedy options, no action was taken. Instead, we're looking at now attempting to open the floodgates under Title V and allow for a complete Title I reexamination of already established pre-construction permits. This would mean,
You know, it always concerns me when anyone says open the floodgates. How are we opening any floodgates? What's going to happen? I mean, are the federal courts just going to come to a halt because of this?
Your Honor, let me, instead of emphasizing through language, emphasize on the outcomes that would occur if we are to look at allowing reevaluation through Title V. That would essentially mean, first, that already established pre-construction permits for facilities that have been running since the beginning of the Clean Air Act would be open for litigation concerning permits that have already been addressed and built upon through alternative other methods. Additionally, we could also look at future implications in terms of businesses who are in the process of constructing a similar facility to East Gen, or just a larger facility that would later then have to open the door once again and during a Title V issuance of the permit, just complete litigation of a facility that they're either currently building or continuing to build. What this means, and more poignantly though, is that once again, Title V is just simply not the appropriate venue to answer these larger questions. As I mentioned prior, there are other venues for which they should have sought an alternative remedy, and to now then argue that Title V is the appropriate area is just simply not the case. This court should hold.
Are you going to tell us what the other venues are?
Yes, Your Honor, to go back a little bit earlier in my argument here, I can readdress the 3 other options. The more, I guess, well, there's a state implementation program, as I mentioned before, which could be reanalyzed to include another review of major and minor source review, but more specifically, Section 1365 of the Clean Air Act, and that is the citizen suit provision, which allows citizens and parties to bring suit against any other facility, even the United States, which is in violation of any part of the Clean Air Act. And once again, it's the FPA stance not to permit or not to, I guess, bar any remedy, but rather simply that this is not the appropriate area. The EPA was correct in noticing that this is not the place to seek that remedy for.
I understand where you're going with my colleague's question. Good, fine question, actually. And I wanted to ask you something about sovereign immunity because I know your time's coming close here. This is tough for you. The CWA explicitly says that removal is allowed, but the CAA contains no such provision. Isn't that evidence that removal is barred here and that we should remand?
Your Honor, there's 2 points I believe mentioned in your question. It begins with sovereign immunity and then removal. I'll first address the removal issue and then move directly into sovereign immunity. In regards to removal, we're looking for removal through statute 1442, that is the federal removal statute. And simply put, we're dealing with a federal issue, as Your Honors noted in prior questioning of opposing counsel. That federal issue is sovereign immunity, and it should be heard in a federal forum of which would still be able to use state law or apply state law. In fact, it most likely would. And this was the same thought process behind the holding in City of Jacksonville, a decision of the 11th Circuit. But that, to take it one step further, the Supreme Court in Morton versus Vancari notes that when 2 statutes are capable of coexistence, we can't say that one is to override or nullify the other. Here, Section 1442, that is the federal removal statute, is completely capable of existing in line with the citizen suit provision, Section 7604E. And that then brings us to the discussion of sovereign immunity through both the federal facilities provision and that citizen suit provision in section 7604. But before we discuss sovereign immunity, it must be noted that the standard for a waiver of sovereign immunity is that set by the Supreme Court in Lane versus Peña, and that is an unequivocal expression of sovereign immunity. It's an extremely high standard, and it's simply not met here. If we first look to the federal facilities provision, section 7418, the Clean Air Act uses virtually identical language to that of the Clean Water Act. And the Supreme Court in the United States Department of Energy versus Ohio ruled on this language within the Clean Water Act and found that through section 1323 of the Clean Water Act, only coercive sanctions would apply, which would exclude punitive penalties. And it did so by analyzing specifically the pairings of processes with sanctions within the language. That same language is used here within the act.
Counsel, I have it's a fundamental, factual, basic question. I get sovereign immunity. What I don't get is why Solaris should enjoy sovereign immunity. They're a private company meant to make money. Why should they enjoy sovereign immunity, which is for the government? There are good reasons for that at times. So help me understand that.
Your Honor, you do mention Solaris in regards to sovereign immunity. To make sure that I'm clear, as representative of the FPA, is it Solaris as operating through FPA as my co-counsel was describing in the original issue? Is that a correct understanding?
That's what I need to understand, because I think the FPA, I don't buy that they're the ones. I think it's Solaris is doing everything, and they're trying to get the benefit of sovereign immunity through the FPA. And that just doesn't, and I understand that you're saying FPA is a federal agency, it should have it, but why should it have it when Solaris is really the one doing everything? I mean, does that make sense? Well, that's my question.
Yes, Your Honor. And let me pause to give thought to your question. I want to make sure that my answer is clear. In looking, as my co-counsel mentioned, and looking at the agreement between Solaris and FPA, it was an agreement for which, while Solaris did have an action, it wouldn't remove the federal essence of FPA and its actions as a state actor. Now, our argument as representatives of the FPA is simply to put that within the Clean Air Act, there is not a waiver of sovereign immunity. And if the federal facilities provision is a good example of this, as well as the citizen suit provision, we really must look to other acts. And a good example is RCRA in itself. RCRA was amended in 1992 to maintain a clear and unequivocal waiver of sovereign immunity. And it's important to look at RCRA in the context of DOE versus Ohio, that Supreme Court case, which was decided in April of 1992. Later, Congress then amended RCRA in October of 1992. And in that amendment, this is going to be section 6001 of RCRA, it both defines what substantive and procedural requirements are to be, and that they are to include both punitive and coercive penalties. It then later says, and I quote, that the United States hereby expressly waives any immunity otherwise applicable to the United States with respect to any such substantive or procedural requirement. This is the clearest waiver of sovereign immunity that exists that we can find within RCRA, and we don't see any similar language here, nor do we see similar actions taken by Congress directly after the decision of DOE versus Ohio.
So is that your argument? Go ahead, Judge Volk. You'll add clarity.
Well, I don't know. I may muddy things up. I just want to know how much clearer Congress can get. We know that the waiver of sovereign immunity doesn't require magic words, as the court has said time and again. The citizen suit provision allows recovery of any remedy or sanction. That seems pretty clear to me.
Yes, Your Honor. And I see that my time may be running a little bit short. Let me answer your question. May I conclude after?
Yes, please.
Thank you, Judge Brewer.
Thank you. So to answer your question, Your Honor, we look at the federal facilities provision for which has been ruled that narrow language should apply, only coercive penalties. Then we turn to the citizen supervision. Those sections cannot be read independently of another. We still need to look at the context of the whole act. We cannot interpret the federal facilities provision as the Supreme Court did in DOE versus Ohio to be narrow and then broaden it through the citizen supervision. In fact, both of these sections reference each other within the act. Therefore, they must both contain the same narrow interpretation as decided on through the Supreme Court. For these reasons, the FPA respectfully requests that this court uphold the EPA's decision to deny VAS's appeal and affirm the decisions of the district court. Thank you.
Thank you, counsel.
Thank you.
Your Honor, I will just briefly address two issues on remand. Opposing counsel stated that the language of RCRA expressly waives sovereign immunity, and there's no similar language in the Clean Air Act. But as I mentioned, in Federal Facilities Provision 7418A, it states that federal agencies shall be subject to any process and sanction, notwithstanding any immunity of such agencies. It appears to be a very clear waiver, but it's followed, by another sentence that hammers this home. No officer, agent, or employee of the United States shall be liable for any civil penalty for which he is not otherwise liable. If that is not a waiver of sovereign immunity in the prior sentence, there is no reason to include an exculpation clause preventing liability onto civil servants, officers, and agents. And finally, Your Honors, to our second issue, the opposing counsel indicates that the MBTA encompasses some greater scienter requirement or an affirmative act, but it simply does not. The MBTA is a strict liability statute, and courts have held that strict liability carries over to its civil provisions as well. Both the Second Circuit in U.S. versus FMC Corp, my apologies, and the 10th Circuit in U.S. versus Caro. For these reasons, Your Honors, we respectfully request this court reverse the lower courts and the EPA's determinations. Thank you.
Thank you.
This honorable court is now adjourned. Judges, I will place you in your deliberation breakout room, and thank you all so much.
We need to join, right?
Right.
Yeah. There we go.
Yes. Thank you, Judge Alloway. Thank you everyone for your participation in this year's Energy and Sustainability Moot Court competition. Judges, you may proceed with feedback at your leisure. Thank you all.
All right.
Maddie, Judge Berger,
okay.
may I interrupt you for 1 second? Maddie,
Sure.
are you back? Can you get back in, Maddie? I want to make sure that in our absence, the prevailing party was not announced. You haven't announced that yet, I think.
Correct. That will happen after feedback.
Thank you very much. I'm
Thank
sorry, Judge Berger, please proceed.
I want you to hear from all of the judges, and so I will make an effort to be quick. We want to congratulate you on your arguments as teams. We thought that you did a very good job, and I will say to you what I said to my fellow judges when we received this problem. I wondered how you were going to be able to do the arguments given the number of issues that were included in it. And I thought as teams, you did very good jobs of distilling it, being consistent in your arguments, and still being able to focus on the strong points for your particular client. And so I want to congratulate you teams on dealing with what was a rather difficult overall problem. And you have presented arguments in a prepared way that I think the judges will agree with me, we do not always see in the courtroom. And so we appreciate too your level of preparation. Judge Volk.
Thank you so much, Judge Berger. When you get to this level, can one of you remind me how many teams competed in this event? Maddie, do you have that information?
If I'm not mistaken, it was 29 this year. 39, my apologies.
Okay, now I want you to pause and think about that for a moment. 39 teams, and it came down to the 4 of you. That is a magnificent accomplishment. When you get to this level, you're not talking about 10 karat gold versus 24 karat gold. You're probably talking 22 karat gold to 24 karat gold. And I'll remind you that 22 karat gold is just about indiscernible from pure gold, which is 24. And that's how I characterize it. You all just did a splendid job. Mr. Cerny, you had some very difficult topics to take up, and you handled those quite well. You should be very proud of your performance. Ms. Cerny, you, and forgive me if I mispronounce your names, I'm so sorry. It's a function of my age and nothing else. But you did a splendid job as well. And you just handled each of the judges' questions very thoroughly and capably. And you certainly have every reason to be proud as well. All 4 of you do. Is it Ms. Brihan or Brihan?
It's Brihan, Your Honor.
You were very tough throughout. You didn't give an inch. I asked you 2 of the most challenging questions that I could, and you stayed on your game. You're respectful, yet firm, and very impressive. And is it Ms. Seguir?
Seguir is good, Your Honor.
Seguir. Your answer to my question was exceptional. I thought you did a fine job. Judge Alloy, I don't want to say went after you because it wasn't aggressive in any way, but it was tough and it was direct, and that kind of thing can throw a litigant off and make a litigant sort of rock on his or her heels. And you didn't do that. You remained respectful. You didn't enter the fray, so to speak. And we do things like that. We sometimes intentionally ask you questions that are misfocused to see if you're going to be disrespectful in any way or dismissive. And I had one of those, and nobody called me out on it, but you just gently reframed things and then respectfully answered it. So all of you really are to be complimented on an exceptional performance. As I say, you made the decision extraordinarily difficult for the three of us, and that's to your credit.
No, it's a benefit of going last. I don't know what else I have to add. Y'all were outstanding. You really should be proud of yourself. And I know what you're thinking, which team won, right? And that's what you want to hear. But I do want to step back from that, because I think we really are too driven in our whole world about who wins and who loses. What we do in law is far more important than that. And the two things that matter in the work that we do are the law and the facts. And as lawyers, we don't control any of those, right? You don't control the law, you don't control the facts. So don't be so hard on yourself. Do what you did today, which was take the case you have and present it to the court in the absolute best way you can. And if you do that, you have done your job. And I can tell you, I started to read this problem and was a bit overwhelmed by it. And I was, quite frankly, extremely impressed how all of you took what were really hard issues and presented them in a way that really was just so helpful. And so all of you, and I'll say that y'all had a little different styles. Some a little more stronger, forceful, other a little quieter in their approaches. What I want you to know is all of those are equally effective if you're always remaining within who you are. That's what's important. And oh my goodness, all of you were just outstanding. Let me say one other thing that hasn't been touched upon. There are judges, and I'm generally one of those who always want to understand in the end, what is the effect of what you're arguing? What's the public policy effect of what you're arguing? And I want to know whether it's a good or a bad thing. And now you may, and I know sometimes you'll think, well, what does that matter? This is the law and this is the outcome it dictates. And that's okay. But there are people who worry about the birds. And I'm one of them. And so, I want to know. And so I think you always think when you're making that argument, here's a framework. We understand, Judge. Here's a framework that we has that does the best that it can in trying to reach fair results. And it may not appear to you in this case that way, but that's the process that we have, and it's necessary. And so, I just think it's always important to understand that everything we do as lawyers, as judges, as advocates, affect people in a very real way. And sometimes it's kind of exciting to get lost in statutes and rules and laws and all that, but they're for a reason. And maybe stability, maybe predictability, maybe fairness, maybe a lot of other things. And so, but you all really should just be extremely proud of yourself. I mean, what an honor it is for us. I think they've said it, but I haven't seen any better arguments or any better presentations in my career as a judge on the bench. So you guys should be proud. And thanks for even coming to West Virginia virtually.
To follow up on what the judges say, I would like, I'm going to ask you all if you have any questions you want to ask us. Maybe your last opportunity to question the judge instead of vice versa, but I don't want you to leave without getting a commitment from you. And that is, once you graduate and you're representing your respective clients, whether that's in the courtroom or elsewhere, that you will give it the level of preparation and focus that you gave to your arguments today. I see you nodding, but I want a verbal commitment.
There you go.
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
All right, you won't forget this then. Do you all have any questions that you want to ask of us? Well, we enjoyed you, and thank you all very much.
Thank you.
Maddie, Mr. Granfield.
Yes, Your Honor. It is a tough act to follow following three incredible federal judges, but I'll try my best. Good afternoon, everybody. For those tuning in on YouTube, welcome. Thank you for joining us. My name is Dan Granfield. I'm a third-year law student here at the West Virginia University College of Law, and I am the Energy Moot Court Chair for this competition. And I would like to echo everything the judges said. On behalf of everyone involved, on behalf of the West Virginia University College of Law Moot Court Board, congratulations to all of you. You worked very, very hard. You knew the issue in and out. You zealously advocated for your clients, and you were very, very impressive. The judges, the College of Law, were all very proud of you, and you should be very proud of yourselves. And first, I'd like to give a huge thank you to our sponsors. First, the sponsor of the West Virginia University College of Law Moot Court Board, Bailey, Javins, and Carter. The sponsor of the title sponsor of this competition, Raymond Heinerman Sr. A special thanks to sponsor Natalie Jeffers, and of course, Babs Calland, who enthusiastically sponsors the winner with a $1,000 cash prize. But without further ado, what you've all been waiting for, of course, the winner of the final round is Team 8, the University of Houston Law Center. Congratulations to you. Both teams should be very proud of yourselves. And with that, I would like to just conclude by thanking the competitors. Thank you to the judges, Judge Berger, Judge Alloy, and Judge Volk. And on behalf of myself and the College of Law Moot Court Board and the staff involved, thank you for everyone who volunteered their time. We hope to see you all next year. Thank you again, and have a great rest of your day. And
Mr. Granfield, before you sign off, I'd like to
Yeah.
know where Team 15 was from.
Yes.
University of Minnesota Law School.
Well, again, to all of you, just terrific job. Very difficult decision.
And you both represented your law schools and law center very, very well. So congrats. You should be
Absolutely.
very proud of yourselves. And thank you again, and we hope to see you next year.
All right.
Thank you.
Good
Have a
luck to
great
all
day.
of you.
Yes, indeed.
Bye-bye.